court. I'm Warren Quavnik on behalf of Gary Froonjian, who is the counter-claimant, third-party plaintiff below. I'd like to reserve 2 minutes for rebuttal, please. I'd also like to thank the court for granting us oral argument. It's my understanding that OA is not commonly granted in non-final appeals, so I'd like to thank the court for this opportunity to talk to the panel directly about this case. This is an appeal of 2 non-final orders that dismissed the injunctive relief counts of Gary Froonjian's pleadings. What we were asking for in these counts was an order requiring the appellees to reinstate him and recognize his position in the company as an owner and 1/3 member of the company, and to cease interfering with those membership rights. We're on a motion to dismiss, which is important given some of the counter arguments that have been made here. Mr. Froonjian's allegations should be taken as true at this posture. The trial court found that Mr. Froonjian, that we had sufficiently alleged that he had been made a member of this limited liability company, as further evidenced by an attachment to the pleadings showing that he had been, a state filing with the court naming him as a managing member. So the court found that we had standing and had sufficiently pledged that he had pled that he had been made a member. But what the trial court then ruled was, as the majority owners of the company, the 2 human beings appellees had the absolute right to vote him out of the company and redistribute essentially his ownership interest to themselves. And that, we say, was error as a matter of law. You cannot vote someone out of their property interest. There's no part of the LLC Act that authorizes that. Under the Act, your ownership interest, your membership, is an ownership interest. It's equivalent to stock in a corporation. And while the Act says that when a vote is required, it shall be by majority in interest, that pertains to the management of the company. There's nothing that would allow members of a company to vote out another member and basically steal his ownership interest in it. The court misapplied the Cortez case, which dealt with voting someone out of a management position. It wasn't taking away his property. It wasn't taking away his ownership interest. In fact, his claim in that case was, because I'm no longer the manager and they're making bad decisions, my interest has been devalued. So it clearly was not about taking away a membership interest. We cited in our brief the Delaware case of Walker and a more recent Middle District of Florida case called Demon Data that I think are on point and hold clearly that majority owners of a limited liability company may not vote away the ownership interest of a minority member. The most clearly applicable indication of that in the Act itself, I think, is the provision that says a member is not even allowed to voluntarily withdraw prior to the dissolution and winding up of the company, and when he does withdraw, the minority member is entitled to, it says he's entitled to, the fair value of his membership. So what could they have done? Well, assuming they could agree to the value of Mr. Froonjian's membership amongst all of them, they could have bought him out, as we say in common language, and I think under the statute that would travel under the assignment provisions of the Act. Or if they couldn't work it out, I think the remedy is you apply to the court to judicially dissolve. The 2 owners who remained could have gone on their way and started a new business, maybe even with the same name, if they had acquired any goodwill. And through the dissolution proceedings, the assets would have been distributed how they're supposed to be distributed. So we think the court erred as a matter of law in saying that he'd failed to state a cause of action and that the majority owners of the company have an absolute right to vote him out of membership and take his ownership interest. As I read the appellee's brief, they seem to agree that this can't be done, that you can't vote away a membership interest. So what they say is, well, he never proved he was a member in the first place. And a few things need to be said about that. First and foremost, we're on a motion to dismiss. Mr. Froonjian's allegations need to be taken as true. And he alleges he was offered a 1/3 ownership interest, that he accepted it, that he contributed months of time and effort to growing and developing the company, that he had acquired through that offer and acceptance a right to share in 1/3 of the profits, and that they unilaterally decided to expel him and redistribute his ownership amongst themselves. Although we weren't required to submit any proof at this stage, attached to the complaint is the filing that one of the appellees submitted to the state of Florida showing that Mr. Froonjian had been added as a managing member, as well as some additional emails showing that this was the understanding. Certainly the allegations, plus those attachments, which really weren't even necessary at this stage, sufficiently show he had been made a member. And in fact, the trial court was correct to that extent of a ruling. The court found that at the, whatever their position may be as to him never having been a member, it's not appropriate on dismissal. It might be a summary judgment issue when there's actually some evidence to be presented. For instance, they say there was a $16,000 contribution Mr. Froonjian was supposed to make. Well, that's their position. We deny that. We don't say it's true. And of course, nothing about that is within the four corners of Mr. Froonjian's pleadings. They also say he failed to prove, and they emphasize prove, that we have consent in writing from the other two members admitting him to the company. Well, again, we're on a motion to dismiss. He alleges he had been made a member of the company, and that needs to be taken as true right now. But that aside, I think the things that we did attach, although unnecessarily at this stage in the proceedings, do show that we had the necessary writings from both of the other members. We have a statement signed by one of the owners, the existing members, admitting him, filed with the state of Florida, as well as emails from the other one showing that this was the agreement. Again, I'm not suggesting we even need to look at those things at this point, because we're on a motion to dismiss, and everything in there alleges that he had been made a member and was improperly stripped of his ownership interest. I think what this hinges on is the incorrect understanding of the trial court that majority owners of a company can vote out a minority owner and take their property interest. I was trying to think from my own perspective. My law firm, my two partners can't decide one day that I'm out, and whatever interest I have in the business is now theirs. It's not the way the world works. I can't, if you own stock in IBM, you can't get a notification that the majority stockholders have decided that your property is now theirs. That's unlawful. There's nothing that authorizes them to do this, and I believe we've stated a cause of action, taking the allegations as true, that Mr. Froonjian is entitled to the injunction he's seeking. Now, I should also point out, I understand the narrow scope of appellate review right now. I'm limited to the injunction claims, and that was addressed to some extent to a large extent, by some prior motions and orders directed to this court. The lower court, though, did dismiss various other counts of the complaint for the same reason, that they had the right to eject him from the company and take his ownership in it. And I understand that's outside the scope of review right now. I'm just hopeful that, and I mentioned this just so this court can be aware of where I'm hoping we're going with this. I'm hopeful that if the court does reverse as to the injunction counts, that would supply the law of the case that might encourage the trial court to revisit the dismissals of the other counts. But I do understand, we're on a very limited scope of review, which is why my amended brief is addressing the injunction claims only. I'm almost down to my 2-minute rebuttal time, so if there's no further questions, I would sit down and reserve the rest of my time.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Rafael Castro III. My colleague is David Wolf. My law firm, Appellate Services Par Excellence, PLLC, represents the appellees, cross-appellants in this appeal, Ultimate Combatant, LLC, and the founding members of the LLC, which are Mr. Palomni and Ms. Nakahara. This appeal comes down to the interpretation of basically 4 words. 3 are found in one statute, 1 is found in another statute. And let me mention what those statutes are. The first statute is 608.4232. This I've defined as the admission to membership provision, and that basically holds that, or states, that no person can be admitted as a member unless there is a majority in interest of the consent in writing. Those are the 3 words. So no person admitted as a member unless a majority in interest of the members consent in writing. The other statutory provision is what I've defined as the LLC amendment provision. That is 608.4231, subparagraph 4, and that provision states, in no event shall the articles of organization be amended by a vote of less than a majority in interest of the members. Now, let me explain why vote is important and why consent in writing is important. In this case, basically what the appellant is alleging is that an amalgam of emails plus the addition of a name on the articles of incorporation constitutes compliance with what is typically known as corporate formalities. In this case, probably business associations formality, because the LLC is a hybrid entity between a partnership and a corporation. The main difference between the LLC and the corporation is no double taxation, which is what applies to partnerships, but you get unlimited liability and you get perpetual existence in the LLC. So in this case, Froonjian doesn't even have a certificate of ownership. Typically in a corporation, if you subscribe to shares, you have all sorts of agreements and allotment of shares, but typically you ultimately get a share certificate. In this case, no ownership certificate or a membership interest certificate, which would be the same thing. Froonjian doesn't also have his name on any company record. Now, I've cited a case from Ohio because in the limited time that I had, I couldn't find any other case that was dispositive and on point. But the Matthews v. DeMore case in Ohio holds that the operating agreement, not the articles of incorporation or organization in this case because it's an LLC, determines the membership rights of the parties. The Berkovich versus Casa Paradiso, which is a 4DCA case in 2013, I think Justice May wrote that opinion, basically holds that an unsigned absentee ballot, very similar to putting a name on an articles of organization, it's basically not a document that includes any terms of what the legal fiction the LLC is trying to incorporate. Typically, there's two ways that a legal fiction like a corporation or an LLC act. They act by consent of the members in writing in lieu of a meeting, or a formal meeting in which minutes and resolutions are formally authorized. In this case, you have none of that. The reason why I filed a motion to dismiss in the lower court is because of three dispositive facts. Basically, there's no operating agreement in this case. So what that actually means is this company was registered with the Secretary of State, but it wasn't formally organized because the main document that you need to organize a company is the operating agreement. In the operating agreement, you would normally have a provision in there that has the shareholders and the membership units that each member owns. And in this case, it's important that they've admitted that Mr. Palomni and Ms. Nakahara are the founding members of the company, and that's in paragraph, I believe it's 11 of the, it's paragraph 11 of the declaratory judgment complaint that I filed. The response is defendant admits the allegations of paragraph 11. They also admitted the fact that the company doesn't have an operating agreement, doesn't have a capital contribution agreement, doesn't have an assignment agreement. Now, the only way that he can be a member of this company is if he's an assignee. The reason why is because by that admission that my clients are the founding members, they would have had to dilute themselves by 16.66% in order to give him the 1/3 interest in the corporation that he claims to have. He's presuming that he has this 1/3 interest. He's not provided any document to the lower court regarding any signature of both of my clients with the terms of what the clients voted on and approved. And the voted on in section 608.423.1 subparagraph 4 is very important because I'll read it again. In no event shall the articles of organization, he's claiming that his client was put on the articles of organization because it was amended. So no event shall the articles be amended by a vote of less than a majority in interest of the members. Both of my clients had a majority interest. They would have had to vote their interest to dilute themselves. Now, they could have done that in two ways, I'll reiterate as I've mentioned before. One way is by a formal meeting in which the secretary of the company basically issues signed minutes, which have resolutions approving what the members want to do. In this case, the members, according to him, wanted to dilute themselves of their 50% interest to give him 16.66%, both of them, so he could have 1/3 of the company. That equals 33.3%. That wasn't done because there is no instrument that has the signature of both of my clients, that has the terms of what they wanted to do, and that has the amount that they held in the company prior to admitting him as an additional member. In other words, prior to diluting themselves in order to bring him into the company. Now, I know I don't have much time left. I have 2 minutes left. The Curtis case is distinguishable on its facts because in that case, the member, the person that was ousted from management was already a member. So in this case, they're presuming that they're a member without any instrument documenting that ownership of title. And this is very similar to a property doctrine. They actually, what this case is about is a forfeiture issue of their membership interest. But they can't forfeit what they don't have. There's a property doctrine called nemo dat quod non habet, which is very similar, that holds that you can't assign or alienate any property interest that you don't have. It's the same concept here. They never had an ownership interest in this LLC. Therefore, my clients never diluted themselves. In the emails, there's different quantities of capital contributions being discussed. I think at first it was 10,000, 20,000, then it went to 10,000, then it went to 16,000. There was never even a meeting of the minds in the emails as to what the capital contribution was. We feel that at the end it was 16,000, but they never contributed that capital. So basically, I would ask that Your Honors affirm the motions to dismiss with prejudice the injunctive relief and all other counts in the complaint. I know the limited scope of review on this appeal is with respect to injunctions, but the lower court dismissed the other counts with prejudice. And unless they can prove that they have a membership interest, they can't presume that. So unless they can prove it, you need to affirm on that count, and you also need to reverse the lower court with respect to the second part, which is the records and accounting cause of action. Because again, if they can't prove that they're a member, then a fortiori they can't get any records or accounting from the company. Thank you, Your Honors.
Thank you.
Appreciate you for hearing me.
I think one of the closing comments was that unless we can prove we had an ownership interest, it can't be presumed. We are on a motion to dismiss. There's nothing that had to be proved at this point. We have alleged that we were made a member of the company. We attached some things to support that, even though it's not necessary in a pleading. These things have to be taken as true. And on this point, the trial court was correct. The trial court found we survive a motion to dismiss on the standing issue. She wrote in her order, I think it's one of the two orders that are otherwise very similar, that Froonjian pleads clearly that he was made a member of the company, and he's attached a document that shows it. I don't know what facts are being referred to now as no vote was taken, there was no secretary. These are made-up facts right now as far as the standard of review goes. There's nothing in evidence. There couldn't be. We're on a motion to dismiss. The comment was made that there's no operating agreement. 608 doesn't require an operating agreement. It says that the parties may enter into an operating agreement. In the absence of one, the statute governs the relationships between the parties. Perhaps an operating agreement, had we had one, would have allowed them to take action to remove a member they didn't want to deal with. Maybe that would have been allowable. But in the absence of an agreement saying they can do it, they cannot. And they seem to agree to that. Again, their position now seems to be he was never a member in the first place. That's perhaps an issue for the evidence to determine. We're on a motion to dismiss. There is something, besides the procedural incorrectness of these arguments, I think there's something really disturbing with respect to the argument that the two appellee owners of the company send Mr. Froonjian and the state of Florida writing saying that you're a member, you're a 1/3 owner of this company. but they now say those writings had no legal significance whatsoever. We don't have a written document signed by his two clients saying that they ever made him a member of the company. Ms. Nakahara filed a signed document with the state of Florida saying that Mr. Froonjian was a member of the company. And the other appellee, Mr. Palame, sent a number of emails signed saying, we all agree you're an equal owner of the company. You'll share 1/3 of the profits regardless of your level of involvement. We cited the statutes in our brief saying emails are writings and they can be signed. We have writings from them. It's remarkable that they're taking the position that, well, our own writings don't mean anything. Even if this was on the summary judgment stage, that would be a remarkable position to take, but we're on the motion to dismiss stage.
I see you're out of time, Mr. Klobnik. You want to wrap up?
We'd ask that the court reverse. Thank you.
Thank you. All right, thank you both very much. Court's adjourned.
All rise.